Hi, this is Brian at Ben Glass Law, and today we're answering a couple of frequently asked questions about auto accident cases in Virginia. One of the questions that we get from parents a lot, and I'm a parent, I have 3 young boys, is I was in a crash and my kids were in the car. Is my case worth more because my kids were in the car? And the answer to that is a little bit complicated. First of all, your case is not worth any more because your kids were in the car. Cases are evaluated based on your medical bills, your lost earnings, your pain, suffering, and inconvenience. And so what parents often want to know is, my kids were in the car, my kids are worried about me, and I'm worried about my kids. Is that an element that gets factored into the settlement of my case? In general, no. The fact that your kids are worried about you, no, you don't get any additional compensation for that. The fact that you're worried about your kids, arguably that goes to your mental anguish, to your inconvenience. I can tell you that in 99.99% of cases, kids survive crashes, and kids are mostly okay, especially younger kids. In the vast majority of cases, they might be a little shaken up, they might go to the ER, but they're normally just fine. And so there's not a whole lot of value that's going to be added to your case just because your kids were in the car and you were worried about your kids. The corollary to that, though, is you need to understand that you have a number of separate claims. So you have a claim for your case, for your medical costs, your lost earnings, your pain, suffering, and inconvenience, but your kids have individual claims of their own, and they have a much longer time to bring their claim and settle their case than you do. And so hopefully it's a relatively simple case where your kid has gotten checked out of the ER, maybe you go see the pediatrician and he's better. And in that kind of a case, he's got his own claim for his medical costs, even though you paid him or your health insurance paid him, and for his pain, suffering, and inconvenience. Minors' claims, instead of having a 2-year statute of limitations, in most cases in Virginia will have 2 years from their 18th birthday. And that's because somebody under 18, you can't sign a contract legally, so you can't release a claim. So you have an additional 2 years from your 18th birthday to bring the claim. The reality is that in most of these cases where it's just an ER visit and a follow-up with a pediatrician, the parent can settle that case. And then what's a little bit different about that case is instead of the parent just signing a release, you often have to go in front of a judge, again, because the minor can't release his own claim, and because you can't technically release his claim, you have to get a court order saying this is an appropriate settlement for that case. But the fact that your kid saw you be hurt or that you saw your kid be hurt doesn't give rise to a substantial amount of increase in the settlement value of a case if it gives rise to any amount of increase in the settlement of a case.